The clock on the wall of the Senate Majority Leader's private office read 11:43 p.m. The meeting that was supposed to last 30 minutes had been going for 3 hours. Empty coffee cups on the table, jackets thrown over chairs, phones face up and lighting up every 90 seconds with messages from people who needed answers that nobody in that room had yet. Because 45 minutes earlier, something happened that nobody in that building, nobody in Washington, nobody watching American politics from anywhere in the world had fully prepared for. The Supreme Court of the United States issued an emergency election ruling tonight, while an active election cycle is in progress. While votes are being cast in states across this country, while ballots are moving through postal systems and drop boxes and counting rooms, staffed by election workers who went to work this morning thinking today would be like any other day in a busy election season. It is not like any other day. What the Supreme Court just did has not been done in this form, with this scope, and with this kind of immediate, nationwide impact in the modern history of American elections. Legal scholars who have spent entire careers studying the intersection of constitutional law and electoral process are tonight using a word carefully. Carefully because they understand its weight. Carefully because they do not use it lightly. Carefully because they know that when this word genuinely applies, it means something has shifted that does not shift back. The word is seismic, not disruptive, not significant, not consequential. Seismic, the kind of shift that happens beneath the surface and changes everything above it, whether the people standing on top of it are ready or not. And tonight, almost nobody was ready. Here's what you need to understand about how this moment arrived, because Supreme Court emergency rulings do not materialize from nowhere. They are the end point of a chain of events, a chain that in this case stretches back through months of lower court litigation, through a circuit split that created constitutional chaos in multiple states simultaneously, through a legal argument that kept getting stronger the longer it went unanswered, until it reached a point where the Supreme Court looked at what was happening in American elections and made a decision that most people inside the legal system believed was coming eventually. Nobody predicted eventually would be tonight. The case originated as a constitutional challenge to election administration procedures operating in several states without proper legislative authorization. The challengers argued that the Elections Clause of the United States Constitution, the provision giving state legislatures authority over the rules of federal elections, was being systematically violated. That procedures affecting how millions of Americans vote were put in place not by elected legislators, answerable to those voters, but by administrators. The first calls out of Washington after the ruling hit went to election officials, not to senators, not to campaign managers, not to the party chairmen, who spend their days managing political narratives and crafting public statements. The very first calls went to the people who actually run elections. The county clerks, the secretaries of state, the directors of election boards in the states, most directly affected by what the Supreme Court just dropped into the middle of an active election cycle. And the conversations those officials had in the first hour after the ruling came down are the conversations that tell you everything about the real-world weight of what just happened. Because those officials were not asking political questions. They were not asking which party benefits or which candidates are advantaged or disadvantaged by the ruling. They were asking operational questions, urgent, immediate, logistical questions that had no clean answers yet. Questions like, what do we do with the ballots currently being processed under procedures the Supreme Court just called constitutionally suspect? What do we tell the poll workers who showed up this morning trained on procedures that may no longer be legally valid tonight? What happens to the votes already cast under rules that the highest court in the land has just found may lack proper constitutional authorization? These are not abstract legal questions. These are the questions of people responsible for the machinery of democracy, who just had a wrench thrown into that machinery at the worst possible moment. And the answers they are getting from their legal advisors right now are honest answers that are deeply uncomfortable. We do not know yet. We are reading the ruling. We are assessing. Stand by. Stand by is not an answer that works when elections are in progress, when ballots are moving, when counting rooms are active, when voters are showing up expecting their participation to be processed according to rules they were told would apply when they walked in the door. That gap between what the legal system needs, which is time to process and interpret and apply a sweeping emergency ruling, and what the electoral system demands, which is immediate, consistent, legally sound administration of an ongoing election, is the gap that is creating the crisis playing out in real time across multiple states tonight. Let us talk about exactly what the ruling says and why its immediate application to active elections is creating this level of operational chaos. The Supreme Court confirmed tonight what election law scholars have been arguing for years about the Elections Clause. The constitutional provision is not a suggestion. It is not a framework that accommodates flexible interpretation based on administrative convenience. What is happening in the courts right now reflects that impossible position perfectly. Emergency filings are going into federal district courts in multiple states simultaneously. Judges are being asked to provide immediate guidance about how the Supreme Court's ruling applies to specific procedures in their specific jurisdictions. Some of those judges are issuing temporary orders. Others are scheduling emergency hearings for early tomorrow morning. All of them are working faster than courts normally work because the situation demands it. And underneath all of the legal maneuvering, underneath all of the emergency filings and the midnight phone calls and the election officials asking questions nobody can fully answer yet, there is a constitutional principle that is worth stating simply and clearly. The rules for American elections must be made by people who answer to American voters. That is what the Elections Clause requires. That is what the Supreme Court confirmed tonight, and that principle does not pause for the inconvenience of its own enforcement. The operational crisis is real. The disruption is real. The impossible position election officials find themselves in tonight is real. But the constitutional requirement that created this crisis tonight is also real, and it was real before tonight. The crisis exists not because the Supreme Court acted, but because election procedures were built on a foundation that the Constitution did not authorize. The ruling did not create the problem. It revealed it and demanded that it be addressed. Right now, tonight, while America watches and waits and wonders what tomorrow's elections are going to look like in a country where the Supreme Court just changed the rules in the middle of the game. Part 3 is where this gets even more complicated. It is a direct assignment of authority. State legislatures set the rules for federal elections. Full stop. When election rules are established or modified through any other mechanism, those rules are operating without the constitutional authorization the Elections Clause requires. The practical problem that ruling creates tonight is this. In the states most directly affected, election procedures currently inactive were not established through the state legislature. Some were implemented through executive orders from governors acting on emergency authority. Some were established through state court orders issued in litigation that moved faster than the legislative process could accommodate. Some were created through administrative rulemaking by election agencies acting under broad delegations of authority that the Supreme Court's ruling now calls into question. Every one of those procedures is now constitutionally suspect tonight while they are being used. The officials responsible for those procedures are now in an impossible position. Continuing to use them risks violating a Supreme Court ruling with immediate effect. The dust will not settle tonight. That much is already clear to everyone still awake in Washington, in state capitals, in the federal courthouses, where lights are burning past midnight because the work cannot wait until morning. But underneath all of the chaos, underneath the emergency filings and the impossible questions, and the election officials staring at procedures, they no longer know how to defend. Something permanent happened tonight. Something that does not go away when the immediate crisis passes. Something that will shape American elections long after the specific ballots being counted right now are certified and the specific races being decided tonight are called. The Supreme Court drew a line, not a suggested boundary, not a guideline for best practices in election administration, a constitutional line, drawn in the language of a unanimous emergency ruling issued at a moment when drawing. It caused maximum disruption precisely because the court determined that waiting for a less disruptive moment was itself a constitutional failure. That line says this: the people who make the rules for American elections must be the people who answer to American voters, legislators, elected, accountable, removable by the same democratic process they are authorized to govern. Not administrators making regulatory decisions behind closed doors. Not executives issuing emergency orders that rewrite election law without a single legislative vote. Not courts substituting their judgment for the judgment of representatives the people actually chose. That line is now part of the permanent constitutional landscape of American elections. Every future election procedure in every state must be built on the right side of it. Every future attempt to change how elections are conducted must go through the legislative process the Constitution requires. Every future shortcut around that process is now exposed to immediate constitutional challenge backed by tonight's ruling. For ordinary Americans who simply want elections they can trust, that line is not a threat. It is a protection. It is the constitutional guarantee that the rules governing your most fundamental act of democratic participation cannot be changed by people who do not answer to you, cannot be modified at administrative convenience, cannot be rewritten through processes that operate outside your ability to hold anyone accountable. The crisis tonight is the price of enforcing that guarantee in real time. It is a price worth paying, not because disruption is good, not because chaos serves democracy, but because the alternative allowing elections to continue indefinitely under constitutionally unauthorized procedures, because fixing the problem is inconvenient, is a price that democracy cannot afford to pay. The lights are still on in Washington, the phones are still ringing, the coffee is cold and the answers are still incomplete.